The Supreme Court has now clarified an important Fourth Amendment question that directly affects when police can enter your home without a warrant. In a new case, the Supreme Court issued a unanimous decision defining the proper legal standard for emergency entries into your home. This case is not just about routine searches, it's about what happens when law enforcement believes that someone inside a home may be in immediate danger. And the court's answer will shape how lower courts evaluate these situations going forward. So let's break down what happened in this critical 9-0 decision. I also want to thank the sponsor of this video, which is Patriot Gold Group. If you've been watching the markets closely, you will know that something unusual is happening. Silver has surged to over 158% in 2025, and this move isn't over yet. It looks like the opening chapter is just happening right now. This is not the finale at all. Gold is up 60%, silver is up 150%, and that kind of move doesn't just happen by accident. Now, as a member of the Second Amendment community, this concept already makes sense to you. You believe in self-reliance, in not outsourcing your safety, and in being prepared before you're forced to actually react. Your finances deserve the same type of mindset that your self-defense also gets. That's why I work with Patriot Gold Group. They help Americans protect their savings with physical gold and silver, and these metals you can have delivered to you or held in a no-fee-for-life IRA. They specialize in rolling over IRAs and 401ks into real, tangible assets that you actually own. Now, this isn't about market panic or anything like that. It's about positioning yourself and putting yourself in the best position to defend your finances like you would defend your life. So if you're interested, check out Patriot Gold Group. You can mention Armed Scholar when you check out to get the best-in-class service from the Patriots that are focused on protecting your investments, or you can call 888-581-3830, and you can get also a free investment guide and see if you qualify for a no fee for life IRA on qualifying rollovers. So you may be asking what triggered this critical case that was just ruled on by the Supreme Court. Well, in this case, police received a report that Mr. Trevor Case had made a threatening statement to his ex-girlfriend at the time, suggesting that possibly he was going to harm himself and that also he would harm police officers if they arrived at his home. Now, when the officers arrived at his home because of this phone call, they observed that there was an empty gun holster, I believe, in one of the rooms. No response from inside or outside the home. They flashed lights in the windows, called for him. He did not answer. And then also they believe there were other circumstances suggesting that maybe there was a potential threat to his safety or to someone else. Believing that he could be inside and injured or maybe in danger, the officers decided to enter his home without a warrant. However, they did, kind of hang outside of his home for over 40 plus minutes before they decided to enter through the front door, which was unlocked. The police officers also, some of them made statements that they did not believe that anything was wrong, but they did decide to enter the home. Now, once they entered the home, Mr. Case was found hiding in a closet. And when he kind of came out of the closet, he was essentially shot by one of the police officers. Now, because of this incident, they also found a handgun in one of the bedrooms, and he was charged with multiple, criminal violations. But Mr. Case decided to challenge the entry into his home, arguing that it violated his Fourth Amendment rights. Now, on review, when this eventually made its way to the Montana Supreme Court, the Supreme Court there upheld the entry using a reasonable suspicion framework. Now, eventually, that was appealed and cert petition was sought to the United States Supreme Court, and the question before the U.S. Supreme Court became, what standard actually governs emergency warrantless entries into a home? The Supreme Court on review reaffirmed the rule that was outlined in Brigham City versus Stewart, which is that police may enter a home without a warrant if they have an objectively reasonable basis to believe that someone inside is seriously injured or imminently threatened with that type of injury. The standard is not probable cause nor mere reasonable suspicion, but an objectively reasonable belief based on the facts known at the time by the police officers. Now, the court rejected the argument that probable cause is required to make these type of emergency aid entries into the home. It also rejected Montana's framing of the test as simply something like a reasonable suspicion, which would be a very low standard. Instead, the Supreme Court clarified that the emergency aid is its own doctrine, distinct from criminal investigations and those type of standards, and the objectively reasonable person standard should be used instead. Now, you may be asking, why is this case so important? Well, this decision really does three major things going forward. It reaffirms that the emergency aid exception that the court made very clear that the officers do not need to wait for probable cause when responding to credible threats of serious injury. If the belief is objectively reasonable, entry is therefore permitted, according to the Supreme Court. That keeps the whole emergency aid exception intact nationwide. Also, after the whole Coniglia versus Strom prior case by the Supreme Court, which was also 9-0, they rejected a broad community caretaking doctrine inside the home. And in this challenge, the case challenge, the court once again avoided expanding police authority beyond just emergency aid. That also prevents lower courts from stretching the doctrine into some sort of generalized public safety justification. Instead, it still has to be tied to the emergency aid situation. Finally, one of the big things that it did is the court actually rejected and kind of corrected what Montana did with their type of an analytical framework and the type of reasoning that they used. Even though the state court reached the correct ultimate outcome, according to the Supreme Court, it used the wrong type of reasoning and analysis. The Supreme Court clarified the proper constitutional standard, which is the objectively reasonable belief, and that matters for consistency across jurisdictions and what now lower courts will have to follow going forward. Now, important also for this case was the presence of the empty holster and also the firearm. The court did not create a firearm-specific exception, but they did acknowledge in the oral arguments and the decision that credible threats involving weapons can contribute to an objectively reasonable belief by a police officer that there is imminent harm. That means that future cases involving these type of alleged threats and firearms will likely turn on, the specific facts known by the police officers, whether the threat was credible, whether the harm appeared imminent. But the standard is not just this automatic, you have this type of justification just because a firearm is present. But the Supreme Court did acknowledge that a firearm could play a big role in determining whether the officer's warrantless entry is justified based on the facts. Now, one thing that I do want to note is something that this decision does not do. The ruling does not allow general warrantless searches into the home or authorize entry just based on vague concerns or replace probable cause for criminal investigations. It applies narrowly to emergency situations involving imminent danger. And so that's kind of how the court tried to narrow this ruling to only apply to those situations. The Supreme Court tried to strike a balance in this case. The home still remains strongly protected under the Fourth Amendment because that is your castle and it has strong Fourth Amendment protections. But the court did say when credible specific facts suggest that someone inside is seriously injured or imminently threatened, the court ruled essentially that officers may act without waiting for a warrant first. And because of that unanimous ruling, it carries significant weight for lower courts, and it will shape now future incidents in cases that play out maybe in a similar way. So that's what happened recently in this 9-0 unanimous decision that was issued in the Case versus Montana challenge. It reaffirmed the emergency aid doctrine and rejected the more loose reasonable suspicion standard that was used by the Montana Supreme Court to justify this entry. So as future cases kind of test those limits as they develop more, I will continue to bring those to you guys to show you, how is this applied in practicality going forward in some of these cases. But if you found this information helpful, if you like this video, make sure you like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content and it should share it to more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.